Court is now in session. You may be seated.
SJC-11836, Commonwealth v. Kristen A. LaBrie.
Good morning, Ms. Mencken.
Good morning. May it please the court. Attorney Michelle Mencken on behalf of defendant appellant Kristen LaBrie. I'm aware, obviously, of this court's interest in the attempt law issue. But if I may, I'd like to begin by briefly touching upon another matter that bears on the attempted murder conviction, and that is that Ms. LaBrie did not have an effective advocate. In particular, her attorney's failure to consult an independent oncologist left him in the dark about important aspects of the medical records that were crucial in the case, as well as the nature of the treatment in general. Specifically, the attorney missed that Ms. LaBrie's lapses didn't only occur during the maintenance phase of the cancer treatment, as the attorney argued to the jury that it did, but in fact, the 6MP had been omitted from a very early stage in the treatment. And B, that lapses like this were not uncommon at all in the treatment of ALL, and in fact, other cancers, and lapses are often covered up.
Now, what's the relevance? I mean, the relevance of that clearly would go to MGH's protocol to say that there is a substantial risk that parents are not going to follow the protocol. But how does it bear on her?
It bears on her because there was absolutely nothing offered at trial by the defense to answer the evidence that her cover-up, her lying about her lapses, her consistently saying, yes, I'm giving him everything I'm supposed to be giving him, was out of a sinister intent. The Commonwealth's theory was that she was covering this up in order to hide the fact that she was actually trying to kill him. But if you get in evidence that, in fact, noncompliance can be explained by a range of different factors, including the fact that, including but not limited to, the fact that the perceived potential risks, the potential side effects associated with medication will appear worse to the person who's responsible for the care than the benefits of giving the medication. So to be more specific, at the time that the 6MP was first prescribed, Jeremy's, the son's condition was vastly improved from where he was. She didn't give the 6MP, yet he achieved remission, attained remission. She was bringing him in to be tested regularly, very frequently, and she is consistently and frequently being told that everything is going according to plan, that he is recovering and doing well as expected, all the while she's not giving this 6MP. So the potential is that this would seem like an abstraction, that the failure to give it was having no discernible impact. And I think what the literature says and what Dr. Patel said at the hearing on the motion for new trial is that you have to sort of weigh that against the potential side effects of adding more chemotherapy into the mix, and noncompliance is seen in circumstances like this. Now, of course, nobody can point to, except for perhaps Ms. LaBrie herself, if we're doing this over again, but nobody can.
Did she testify at trial?
She did testify at trial, and she testified primarily that her reasons for not giving all of the medication was her fear that the medication would make him sicker, and he already was sort of at his limit. She did also testify that she thought he was better. And she didn't know whether one medication or another medication would or wouldn't save his life. So that's the potential relevance of the sort of body of literature and evidence about the fact that noncompliance happens. You know, you've got the Commonwealth on the other side saying MGH didn't need a protocol because this is what they ask all families to do, and of course all families do it because that's the decent thing to do. And the only possible explanation for withholding this medication would be she wants to kill him.
Was there any evidence that she had gone to, brought her son to the doctor, and had said to the doctor that he's doing better. Can I withhold some of the medication, or can I stop administering the medication, or something to the effect that the doctor may have given her a new prescription, and she said, I really don't need it because I still have a backlog of pills.
No, in fact, the evidence was that that did not happen.
Okay.
There was one occasion when she did complain sort of late, it was in the maintenance phase, when she did complain that the 6-MP, that her son was spitting it out and it was hard to get him to take it, and she was prescribed an oral suspension, and she didn't give him that either. So no, she was not, and this was actually a problem for her defense. I would say the theory of defense that was asserted was inconsistent with the evidence in this other way as well. Now, that's not to say that her concerns weren't real or that she was lying at trial about being afraid of sickness, but that certainly didn't explain it didn't fully answer all of the Commonwealth's evidence about her failure to do what you're suggesting, to speak up more vocally about it. And the other significance of this, the discrepancy between what the attorney argued and what the evidence actually showed, is obviously the discrepancy itself. So this was pointed out to the jury in the prosecutor's questioning of Ms. LaBrie. It was pointed out to the jury in the closing argument. This theory of defense had some holes in it, and that was pointed out to the jury, and that in and of itself is damaging. That is prejudice from the attorney's failure to fully understand what the evidence was. And if he had consulted with an oncologist and gone through these voluminous records with an expert, I think it's safe to say that would have certainly reduced the chances that a mistake like that could have been made, and it did prejudice Ms. LaBrie. So just...
You could turn to the issue of attempted murder.
Absolutely.
And I guess my question is, why is attempt not a lesser included of murder? That is, it's the same as murder, except it lacks the element of the murder being completed, as opposed to a wholly separate crime for which there's an element of it being uncompleted.
Well, first I'll say that I don't think that the two things are necessarily the same. So I think that it's possible that attempt can have as an element the requirement that non-completion be proven and still be treated as a lesser included offense for purposes of double jeopardy. And I think that the appeals court's recent decision in Commonwealth versus Aldrich illustrates this. It picks up on this, Aldrich picks up on this thread from Poro, where you talk about sort of if there's an element that's routinely not disputed and the essence of the offenses are pretty much the same, then sort of we're going to relax the elements test a bit.
You're suggesting, I take it, that this would have been fine. This attempted murder charge would have been fine if her son had lived. Because he didn't live, then the attempted murder charge goes away.
No.
I think that the problem with the attempt and murder is the lack of evidence of a causal connection, or the deficiency of evidence of a causal connection between Ms. LaBrie's omissions in medication and the relapse of cancer.
The inability to prove beyond a reasonable doubt that one led to the other.
Exactly. That's the problem with both offenses. So the Commonwealth did not charge. So get back to the hypothetical that you've suggested. He lives, and initially she was charged when he was still living with reckless endangerment, and none of what I said before about the.
Let's say the Commonwealth proves that she intentionally failed to give the medication that was required essentially to increase his chance of living with the intent to kill him. But he lived. You're saying doesn't work.
Well, it would. I believe that in order to satisfy the overt act element, you would have to show that her omissions, that the intent to kill alone doesn't make her guilty of attempted murder. That there has to be
it's certainly not.
proximity.
An overt act.
Correct, an overt act. So call the overt act the omission, in this case, the omission of medication. And the question remaining is, did that omission come close enough? Was it a competent means of causing his death? Is there proof that you could expect that this would actually cause his death? Those things would be required in addition to the intent. So,
What if the crime under 265, Section 16, did not have the word attempt, but said trying to kill somebody, something like that, instead of the word attempt? Would it
Whoever seeks or something?
or seeks attempt?
Yeah.
Yeah. Is your analysis different?
I think it is, and I think it's, you can look at all of the case law that's construed both this statute and the general attempt statute the same. I think it's because of the word attempt. And, you could conceive of the attempted murder statute, 265, Section 16, as almost like assault with intent to kill, only for non-assault crimes. But that's not how the statute has been construed to date, and I have to emphasize.
It actually has it explicitly in there that it can't be, right? I mean, by any means not constituting an assault with intent to commit murder.
So I guess what I'm suggesting is that that language with that exception, making it a sort of a non-assault assault with intent to murder, if you follow me.
Yes.
So this would be to avoid duplication with assault with intent to murder. This is sort of assault with intent to murder by other means that aren't assault, including poisoning, strangulation, drowning, and whatever else you can think of, omission of medication perhaps. But Ms. LaBrie's case has to be adjudged by the law that was in effect at the time of her trial. And if you decide to construe the attempt statute that way.
This is not the attempt statute. This is the attempted murder statute.
Thank you, I stand corrected. If you decide to construe this statute distinctly from the general attempt statute, or if you suggest to the legislature that it should revise the general attempt statute or attempt law, or whatever you may see fit to do with this body of law, can't be applied in this case.
Well, it is different than the general attempt statute. It's not the same.
Correct. It's not the same statute and the language is different. However, appeals court cases have said repeatedly, and I think I cited 4 different appeals court cases in my brief, I believe that may not be accurate, as well as the Superior Court jury instructions that say these are the same. Whether you're charged under the attempted murder statute, 265 Section 16, or the general attempt statute, the elements are the same. And those cases draw upon the cases of this court holding that one of the elements is the element of non-completion. That was the law at the time. We have cases of this court and of the appeals court that not only just list non-completion as an element, but actually comment on that element. For example, in Commonwealth versus Hamel, an appeals court case in 2001, the court comments that there was adequate evidence of intention and non-completion. In Marzilli, a decision of this court in 2010, the court comments.
That Marzilli wasn't an attempted murder, though.
No, that's correct, it wasn't. So, but starting from the premise that at least at the time of Ms. LaBrie's case, the elements of both are the same. And they're drawing from a single well, these old cases defining attempt as this unique creature in Massachusetts, and not sort of merely just listing this as an element as if it derives just from the statutory language, but actually talking about whether there was evidence of that, evidence of that element of the crime.
Can I
Would you
turn-
say that, go
No,
ahead.
you go ahead.
Would you say that the Commonwealth proved that the defendant did an act designed to result in death with the specific intent that it do so?
What I would say is that there was sufficient, what I would concede is that there was sufficient evidence for that to be presented to the jury, and that the jury was instructed consistent with the law at the time, and the jury evidently found that overt act had been proven. The uniqueness of the attempt crime in Massachusetts is something we're sort of stuck with at this point. We have this unique pleading requirement that the overt act be pled explicitly. My time is up. I won't go through all of the additional unique characteristics of attempt, but I'll just emphasize that that is the law that governs the adjudication of this case.
Thank you.
Thank you.
May it please the court, Marcia Slingerland for the Commonwealth. With me is Assistant District Attorney Kate McDougall. She was the trial prosecutor in the case. If I might direct the court's attention to transcript 6, page 54, lines 6 through 8, the judge instructed the jury, the Commonwealth must prove that the defendant permitted an injury to occur and acted wantonly and recklessly in permitting that injury to occur. That is designed to answer the reply brief of the defense counsel with regard to the judge's instructions on permitting substantial injury, wantonly and recklessly permitting serious bodily injury and substantial bodily injury.
Well, he also went on to say serious bodily injury includes a substantial risk of death.
He did say that.
Which suggests that a substantial risk of death alone is sufficient to prove serious bodily injury, and that does not seem to be correct, is it?
I think and the reason I say that is the instructions need to be read as a whole. He twice told the jury that an injury had to be permitted, and it had to be wantonly and recklessly permitted to occur.
But try my question. It is not correct that a substantial risk of death alone is sufficient to prove serious bodily injury, is it?
If under the statute, serious bodily injury is defined as a substantial risk of death. Serious bodily injury.
Right, but bodily injury is
Under which
defined-
statute?
The serious bodily injury is under the permitting a injury to a disabled person, and substantial bodily injury is to a child, and this court has construed the two to be essentially the same.
But substantial bodily injury says it's bodily injury that results in a substantial risk of death. There still needs to be bodily injury, and bodily injury is defined as a, quote, a substantial impairment of the physical condition, close quote.
Well, the judge instructed that they had to find that an injury occurred. And there was no objection, no comment by defense, no, we need bodily injury. The judge said, you've got to find that an injury occurred as to each offense, and he said it with
Didn't the
regard
judge
to each.
also say that injury includes a substantial risk of death?
Substantial bodily injury includes a substantial risk of death, yes.
Serious bodily injury.
Serious bodily injury or substantial bodily injury. So that's why I directed the court to that portion of the instructions, as well as page 69 of that transcript, lines 9 through 12. He specifically told the jury that they had to find that the defendant's conduct permitted, and again, this is not an assault and battery case, and I think that's where part of the confusion is. This is a permitting case by failing to act. That's the claim here. The defendant permitted injury, serious bodily injury, substantial risk of death, by failing to act, by failing to give him the prescribed chemotherapy.
But that sounds like endangerment to me.
No, because an injury was required by the instructions. Defendant did not object at all. He said an injury. He didn't say bodily injury. He said serious bodily injury includes a substantial risk of death.
If you could go to the first point that Ms. Mencken made, would it not have mattered to a jury if the jury had heard that there are many, many, many parents out there who, for whatever reason, are not following the protocol with regard to cancer treatment, and that this is a huge issue with regard to pediatric cancer care, that she's not a lone instance of this, but that 20 to 30% of parents, in fact, have serious issues of following the protocol. Would that not matter to a jury in evaluating this evidence?
Well, the judge ruled on that and really felt that what that would have been permitting is that Dr. Patel would have been talking about what other people's intent were, and that is not relevant. That would not have been relevant, because the relevant issue here, and Dr. Patel acknowledged he couldn't say what the defendant's intent was, particularly in light of the fact that she not only withheld chemotherapy, but made affirmative false representations about the fact that she was
But
not.
I mean, I'm just thinking about this, and maybe this doesn't work, but take a child sexual assault case where the Commonwealth calls an expert to say, I can't tell you anything about this child, but I can tell you that children who have been sexually assaulted tend to do X, Y, or Z, or they don't disclose, or I mean, in other words, there's evidence about what happens of generally with if you are an abused child, and wouldn't it come in like that?
That wasn't how it was presented, however. Dr. Patel, when he testified, well, he agreed completely with Dr. Friedman, and that's what the motion judge found, and so it was not ineffective assistance, which is the claim.
He agreed with Dr. Friedman that this treatment was necessary.
Right, and that over 2 weeks is going to be something that causes serious concern. And he said, he testified at length about, there's various reasons, they don't understand. Well, the problem is this defendant testified and made numerous statements that she well understood what was required of her. And she understood that it would have been like her statement was, pushing him in front of a car, that it was indeed lethal. That evidence about what other people might have done or it was a common occurrence would not have undercut that aspect of the defense. It simply was.
I take it there was no outward manifestation of the boy's, of the degradation in his health, and that it was only discernible by the taking of sophisticated blood samples, by administering sophisticated blood tests.
He got very sick at the end, though.
He got very sick, and then Dr. Friedman was concerned, and she conducted tests and determined that cancer cells had returned to his lymph nodes and was in his
How
blood.
much time was there when he appeared outwardly to have suffered a deterioration in health?
It was the defendant claimed in her testimony he was constantly sick, he was suffering, and that's why she was withholding the medication, that she didn't want to contribute to this poor health. There was conflicting evidence on this. There was a lot of evidence that he went to school. He went to school in September 2007, despite the fact that chemotherapy was administered that month.
But were there any outward manifestations that his condition got worse?
During maintenance, during
Yeah.
the end period there, toward the end,
And how long a period was that, where he began to look worse?
was not exactly totally clear how he,
2 weeks, a month?
Well, when did he come in with the fever and the cough?
early February of 2008, that was about
Died
February
in March
4th.
of 2009, right?
Yes. He was determined to have relapsed, and there was a lot of testimony about, as a result of that relapse, could you cure him? And essentially, they tried to cure him. The same drugs didn't work because the cancer was resistant to them. So if they were going to cure him, they had to do a bone marrow transplant. Even if they could find a donor, and even if they could get the marrow to fit with his marrow, the likelihood of living was 25 to 30%, and the defendant and the father of the child decided it wasn't worth it.
Was there any testimony or any evidence with respect to why the cancer was resistant?
Yes, Dr. Friedman testified that the treatment initially is designed to kill the cancer, and they use certain drugs, and the idea is to kill it. However, if it returns, I believe she testified, they are resistant to this frontline treatment that they hopefully
Because
expect to use.
the antibodies
Have developed.
kick in, yeah.
And the reason that this returned What was the evidence on that?
The reason, well, Dr. Friedman said there was the withholding of chemotherapy during that. She withheld it for 5 months during maintenance, when that was a significant part of the child's treatment, created a significant risk that the cancer would return, given the studies there were on the importance of 6-MP, methotrexate, and prednisone in treating cancer during that time.
But I gather there was also a 10 to 20% risk that he would have died even with the treatment.
There was a, I believe, 85 to 90% chance of his surviving with the correct application of the treatment.
So 10 to 15% chance that he would not survive even with the treatment,
That's right.
which is why you could not prove murder.
Right, which is why attempt was charged. I am happy to go to the attempt part of the argument.
So on that point, it seems to me that the thrust of your argument is we're not dealing with 274-6, we're dealing with 265-16. But, as Ms. Mencken points out, 265-16 just says whoever attempts to commit murder by various kinds of things. So the word attempt is front and center.
Attempt is front and center, but when you look how this statute came into being along with 274 Section 6, they both were enacted at the same time. They were codified, actually.
I mean, 274-6 goes way back. I mean, in
They
terms of
both do.
common law crime.
Well,
But
they,
does attempted murder per se, as opposed to attempt to murder, go back?
well, there were two statutes, assault with intent to murder, and then there was attempted murder, which eventually became 265 Section 16, but they both were codified in the acts of 1836. And there's that language, that failure to complete, fail in the perpetration, fail in the completion. That language is glaring in 274-6, but that doesn't appear in
You're saying they're very different crimes.
very different. This is a specific crime that targets, clearly, attempted murder by various ways. The general attempt statute, as I said, which was enacted at the same time, was designed, as it said, where there was no express provision made by law for the punishment of another attempt, then you go to the general intent statute. And I think that's why the cases have become, they use the word failure, but usually it's not an issue. I mean, either there's a successful attempt or not, usually. And so
There was agreement at trial, though, about the need for the element, wasn't there?
need for.
Didn't the parties agree on that was an element?
Well, both requested that it be given because that's, it says failure. I mean, that's the nature of an attempt, that it's not a successful completion. That doesn't mean the Commonwealth, I guess, has to prove it beyond a reasonable doubt. And the judge did say, he had one line that said, attempted murder, of course, does not exist if the murder was completed. But it really wasn't an issue here. Nobody was claiming, especially the prosecution, that the withholding of medication had caused that death because of that 15 to 20% or that 10 to 15% chance of survival.
What do you say about your sister's argument, if I understand it correctly, that the appeals court has construed this statute 3 or 4 times, and it's put a gloss on it that essentially makes it the same as Chapter 274, Section 7?
I guess I would say it was dicta, and actually I would cite you to Perkins on criminal law, 1969 version. At page 653, he talks about this very situation where you can't prove one way or the other whether the attempt was successful or not. And that really shouldn't matter because the gravamen of the crime here is that intent to murder, which the jury found, and that overt act, which was committed in furtherance of that intent. That is the blameworthy conduct that was targeted and charged and proved. And whether
just any overt act or an overt act?
Don't you need at least the risk of death?
Well, I would cite you to the Kennedy case, one that threatens death according to common apprehension. When you put poison, in that case, you put poison in somebody's cup knowing they're going to drink. It doesn't matter how much poison you put. It's clear what you're intending to do. You're wanting to kill him. And that's, by withholding chemotherapy from a cancer patient, that's pretty clear
Okay,
what you're
but
intending.
supposing you've selected a kind of poison that requires 10 treatments, 10 doses. And after the first dose of drinking tea with this stuff in it, the object of the hoped killing says, look, this stuff is awful. I'm not going to drink tea anymore. I've given up on tea. Is that one dose enough under the statute, Section 16?
I think it depends what the person knew at the time.
He's intending to kill him.
But there are cases where someone with intent to kill someone puts something in their food over time, knowing that over time this will indeed kill them. And the fact that they're intercepted before they get to the level of dosage would still be an attempt, right? It
still absolutely would be, because what you're punishing, again, is that act and that intent to kill that come together, and that's what happened here. Over a long period of time, this is not just the 2 weeks, this is 5 months that she withheld that, deliberately knowing that the child could die. Her statements, she made many statements. I understand what's required of me. I know what I need to do. I know it could be lethal, essentially, by pushing him in front of a car. Nevertheless, she continued in her behavior, and sure enough, there was a relapse.
How far do we take this? I mean, imagine a situation similar to what we had here. 25 to 30% chance of survival with the continuation, with the bone marrow transplant. Father says, I don't want to put my son through that, and I'm going to let him die. Is he guilty of attempted murder?
No.
And
because he doesn't intend to murder him. He intends to let him
Nature take its course?
Let nature take its course. It is too, and I think there may have been testimony that Dr. Friedman agreed with the decision that was made, that it was a legitimate.
So what distinguishes the two? In both situations, you engage in a course of action which you know will result or think is very likely to result in death. I mean, how far do we go in terms of this attempted murder provision for the failure to furnish treatment to somebody who is very, very seriously ill?
Well, you here had clearly with this defendant, you have that overt act and the intent, but with regard to the husband, he was...
that's merely by way of example. I don't mean to implicate him, but I mean,
Sure.
There are many parents who were faced with this dilemma.
Well, he was working with Dr. Friedman, and there was a lot of testimony about what she did after the relapse was discovered, and he participated. I'm not sure of the exact details of that because I was focused on, it didn't matter what happened to the child after the attempt was made for purposes of this argument, but there was a lot of testimony about what was done. They gave different types of chemotherapy. I believe they gave intravenous therapy. And so the father clearly was acting in the child's best interest. He didn't want to murder him. But as Justice Botsford said, he was ready to let nature's take its course. And Dr. Friedman was working with him. He was following the medical advice in the case.
Okay, thank you.
Thank you.